of the Constitution of Kenya 2010. Furthermore, my lord, the respondents, the communities or these marginalized communities, they already face barriers in obtaining national IDs, and exclusion from adequate public participation made NIIMS discriminatory, violating Article 27 of the Constitution, which requires for equality and non-discrimination.
Do you have a definition of discrimination?
My lady, in the Constitution, there is no direct definition for discrimination. But what amounts to discrimination is, according to Article 27 of the Constitution?
Council, I just want to know the definition of discrimination. If you do not have it, kindly proceed.
Discrimination is the unjust or prejudicial treatment of different categories of people, especially on the ground of ethnicity, age, sex, or disability. My lady. Pardon? From the dictionary.
Which dictionary?
The Oxford Dictionary, my lady. We submit that we urge this court to declare the enactment of Section 9A of the Registration of Persons Act unconstitutional, as it failed to adhere to the mandatory requirements of public participation and parliamentary procedure under Articles 10 and 118 of the Constitution of Kenya 2010. I'd like to cede the floor to the bench for further direction.
Honorable members of the bench, before you is Whitney Nyarangi, appearing as second counsel for the appellants, and I'll be addressing issue C and D, where the key issues are whether the collection, storage, and utilization of personal data under NIIMS violates Article 31 of the Constitution that guarantees privacy rights, and whether the implementation of NIIMS disproportionately discriminates against marginalized communities, contravening Article 27 of the Constitution. I'll begin with issue C, and I'll be submitting in 3 limbs of arguments, and may it please the court, I would like to proceed.
Counsel, how long are you going to take?
12 minutes of the allocated time. Proceed. Thank you. The appellants submit that the collection, storage, and utilization of personal data under NIIMS violates Article 31 of the Constitution. 1. The absence of sufficient legal safeguards for data protection. My lord and my lady, the appellants aver that NIIMS collects highly intrusive data, including biometric and geospatial data, which include fingerprints, retina scans, and GPS coordinates. My lord and ladies, this level of data intrusion violates Article 31 of the Constitution that guarantees privacy rights. My lord and lady, in Katiba Institute and another versus the Attorney General of the case of 2020, Justice Makau in the High Court held that any state-driven collection of personal data must be accompanied by a robust data protection measures to prevent abuse. My lord and ladies, the respondents may assert that the Data Protection Act came after the implementation of NIIMS, but my lord and ladies, this does not deal with the risks that the implementation of NIIMS brings about. The implementation of NIIMS...
Counsel, can you kindly go back to what you just stated on a few seconds ago? I want you to rewind your statement.
About the Data Protection Act?
Yes.
Very much obliged, my lady. I just stated that the Data Protection Act was enacted post facto, meaning it was enacted after the implementation of NIIMS. And I stated that the respondents may assert that there are regulations that may come even after the implementation of the Data Protection Act.
No, not that part. There's a part you stated that when data collection, when collecting data like retina scans and DNA and fingerprints, there has to be something. I want you to rewind. You used the case on that.
Much obliged, my lady. I stated in the case of Katiba Institute and another of 2020, Justice Makau in the High Court held that any state-driven collection of personal data must be accompanied by a robust data protection measures to prevent abuse.
Counsel, let me draw your attention to paragraph 23 of the case facts.
Sorry, paragraph?
23 of the case facts.
Yes.
In paragraph 23 of the case facts, we see that NIIMS, the respondent contended that data collection under NIIMS will be stored in a highly secured central database with multi-layers of encryptions and access control. Isn't that enough measure for data protection?
Much obliged, my lady. My lady, I'd like to lead this court to Article 24 of the Constitution and state that the collection and implementation of NIIMS of the collection of data for the citizens of Kenya does not meet the proportionality test. It significantly does not meet the test. In this sense, the proportionality test is in 4 parts. There needs to be a legitimate aim, it should be suitable, it should be necessary, and it should have a balance. My lady, in the part of necessity, highly intrusive data such as the collection of GPS coordinates and collection of retina scans is not necessary for collection of data for the registration of NIIMS.
Counsel, I'm not satisfied with your answer. I've asked you, isn't that enough is that enough data protection regulations put up by the respondents?
Much obliged, my lady. And as I stated before, the Data Protection Act was enacted post facto. We do not have any reliance that the data collected is going to be secure. What about right now before the Data Protection Act was enacted? That's my submission. In furtherance with that, my lady, in the other case of India, the Supreme Court held that the data collected for biometric purposes without strict regulatory framework violates the right to privacy and therefore should be declared unconstitutional.
Counsel, you keep on mentioning you've mentioned street regulatory frameworks. And in paragraph 23, I see like this is enough regulational frameworks for the NIIMS which was employed.
My lord and my lord and my lady, I'd like to direct you to the principles of data protection, section 25, which states that, just a minute. In the principles of data collection, it states to us that data collected should be adequate, relevant, and necessary. My lady, the collection of retina scans and GPS coordinates is not necessary for unique identification, and even if it is stored by the Data Protection Act and protected, it is not necessary and is highly intrusive. My lady, I would also want to direct you to another principle of the Data Protection Act, which states that the data that is collected should be processed in a lawful and transparent manner. The data subjects, on the other hand, should be informed how their data is being used, and as I proceed to the second issue, I will address that with substantial. Thank you. I would also want to state that, in furtherance with my argument, I was stating about the other case, which states that data collected without proper legal framework violates the right to privacy. I would also want to state that the collection of data under NIIMS does not meet the constitution proportionality test as enshrined in Article 24 of the Constitution. My lord and my lady, the government does not demonstrate that the broad scope of data collection is necessary for the implementation of NIIMS. NIIMS collects highly intrusive data, and as I've stated, the collection of retina scans and GPS coordinates is highly intrusive. Existing identification methods such as the IDs, passports, and birth certificates have served the same purpose years without requiring excessive data collection. My lord and my lady, in Katiba Institute, again the case of 2020, the High Court emphasized that personal data collected must be justified and accompanied by safeguards. Similarly, in the other case, the Supreme Court of India held that collecting biometric data without clear necessity constitutes a violation of privacy rights. And as I've stated, it is not necessary and it does not meet the proportionality test, hence should be declared unconstitutional.
Counsel,
Yes, my lady.
let me draw attention to paragraph 1 of the case facts.
Paragraph?
1 of the case facts.
Yes.
We see that the system sought to consolidate all personal information of Kenyan citizens and foreigners into a single digital platform for efficient service delivery and national security purposes. This NIIMS has a good purpose. To the ages of paperwork and leave alone a more efficient and less expensive way of Kenya.
Very much obliged, my lady. As I've stated in the case of India, the other case, it has posed many risks. The implementation of it did not work in India and it is not going to work here as well. My lord and my lady, the collection of data is highly intrusive, and as much as it is going to be to enhance national security and facilitate efficient service delivery, equal application of an unfair system is not true equality. And you shall see that even as I proceed to the second issue.
Before you proceed, Counsel, could you propose specific reforms that would address the issue of concerning regarding accountability as well as protection of biometric data?
Very much obliged, my lord. My lord and my lady. Less intrusive alternatives, such as decentralized databases or limited biometric collection, can be used in this case. And I would like to lead this court to systems such as Germany and Canada that have used less intrusive systems, such as decentralized identity management systems. And let me retract my statement. I would also want to state that one alternative will be a decentralized identity management system where data is stored in a local registry rather than a centralized database system. My lord and my lady, we have witnessed that IDs, passports, and birth certificates are systems that have worked before, and burdening the citizens with discrimination under NIIMS would not be an ideal and should be declared unconstitutional.
You've stated that the NIIMS system did not work. It's similar to the DAR system, and the DAR system failed in India, and you propose to say that the NIIMS system will also fail in Kenya. I'd like to draw your attention to paragraph 15 of the facts, where we see a system just in Estonia and India. Can you address on that?
My lord and my ladies, even as I will continue with my submission, you will get to see that for someone to attain the NIIMS or for someone to get an identity verification through NIIMS, they need to have the prerequisite requirements, including the birth certificates and the national identity cards. These are prerequisite requirements for the implementation and registration of NIIMS. My lord and ladies, move with me to paragraph 14 of the fact sheet, where it states that regarding discrimination, the appellants present evidence showing that communities in border regions, particularly the Nubians and the Somalis population, face systemic barriers to obtain birth certificates and national identity cards, prerequisites for Huduma number registration. If this is a system that is going to discriminate against Kenyans, the Kenyan citizens, then it is unconstitutional and it will not work.
Do you have a definition of discrimination?
As per the Oxford Dictionary, and as my fellow counsel had stated earlier, I would also want to do the same and say that discrimination is the unjust and or prejudicial treatment of different categories of people, especially on the grounds of ethnicity, age, sex, or disability. And this can further be discussed in Article 27, subsection 4 of the Constitution of Kenya. Thank you. My lord and my ladies, I'll further want to submit that the Supreme Court of Kenya, in the Court versus the Republic of Kenya case of 2015, reaffirmed that any infringement on fundamental rights must meet the least restrictive means test. And as I stated earlier, the government did not explore or want to know any other means rather than what will be highly intrusive to the citizens of Kenya. The risks of data misuse outweigh the benefits. This is not a balance according to the proportionality test as enshrined in Article 24 of the Constitution. The risk of implementation of NIIMS is mass surveillance, identity theft, unauthorized profiling, and discrimination. My lord and my ladies, the government claims that NIIMS will improve service delivery and national security, yet these claims are unsubstantiated. Meanwhile, the risks associated are misuse, data misuse, surveillance, identity theft, and discrimination are severe and well documented. My lords and ladies, past cybersecurity breaches such as the 2019 Huduma number data leak demonstrate that a centralized database poses security risks and threats. In furtherance with my argument, similarly in the Digital Rights Island Limited and Minister for Communications of 2014, the Court of Justice of the European Union held that mass data collection without proper protection violates privacy rights. My lord and my lady, the risk of state and non-state abuse of data is also an arising issue. Potential mass surveillance and outreach is also an issue. The collection of GPS coordinates is a risk for mass surveillance for the citizens of Kenya. My lord and my lady, I also want to submit that the threats posed by the cybersecurity breaches can also be confirmed by the previous data leaks of the 2019 Huduma number. My lord and my ladies, in conclusion with my first issue, the collection, storage, and utilization of data under Article 31, it violates the rights of privacy that are guaranteed in that article. Without strict regulatory frameworks, NIIMS remains a grave threat to privacy rights, warranting immediate nullification. May it please the court, I would like to proceed to my final issue and conclude.
Counsel, your time is far much spent.
I'd like to seek the court for 1.5 minutes to conclude with my issues.
I'll give you 3 minutes.
Thank you. My final issue is whether the implementation of NIIMS disproportionately discriminates against marginalized communities, contravening Article 27 of the Constitution. The appellants argue that NIIMS disproportionately discriminates against marginalized communities under Article 27 of the Constitution, and I'd further discuss this in two limbs of argument, and these include the system's exclusion of marginalized communities, pre-existing barriers to registration. My lords and my ladies, move with me to paragraph 14 of the fact sheet, where it states that for one to obtain a Huduma number, they need the prerequisite requirements, including birth certificate and national identity cards. This has been an historical barrier for the Nubian and the Somali communities. They have not been able to get the birth certificate and the identity verifications for the implementation of NIIMS, and even before, they were barred from getting the birth certificates and the identifications. My lord and my ladies, in the Nubian case, the Nubians Forum and 2 others versus the Attorney General and 6 others, the High Court ruled that historical exclusion of Nubians from citizenship rights must inform legal frameworks. My lord and my lady.
Do you have the facts to that case?
Yes.
State them.
In the Nubians Forum case, we see that the Nubians and the Somali were barred from getting birth certificates, identification cards, and did not have access to other rights because of historical injustices that were witnessed before. My lord and my lady.
Counsel, are you sure about those facts?
Yes. My lord and my lady, I would also want to state that for one to get citizenship rights, as NIIMS is being implemented, the NIIMS implementation is to enhance national security, facilitate service delivery, and eliminate corruption by removing ghost beneficiaries from state programs. My lords and my ladies, if it is to enhance national security and facilitate efficient service delivery, the people from the Nubi and Somalis are significantly discriminated from this because they do not have the prerequisite requirements for the registration of the NIIMS. My lord and my ladies, violation of the right to non-discrimination under Article 27, subsection 4 of the Constitution, it explicitly prohibits ethnic, racial, and social discrimination. My lord and my ladies, Nubians and Somalis are barred from socio-economic privileges such as education and health services. My lord and my lady, in the Republic versus Independent Electoral and Boundaries Commission and another, Judge Musyoka of the High Court stated that in this case, it is significant for addressing the constitutional requirements for inclusivity and non-discrimination. I would further like to lead this course to Article 56 of the Constitution that states that,
Council, your time is up.
in conclusion, I beg for one discretionary minute to finish my
Council,
submission.
I've given you 3 minutes to conclude.
Okay, let me conclude and I finish. In conclusion, I'd just like to state that this court finds that NIIMS discriminates against marginalized groups under Article 27 of the Constitution. I'd like to sit the bench for further direction.
Before you sit, if NIIMS was to be reformed, what targeted measures would you propose to ensure that these communities have equitable access to the registration?
Pardon?
What if NIIMS was to be reformed, what would you propose would the measures to be implemented to ensure that the Nubian communities which are being discriminated have access to equitable registration?
Very much obliged, my
and I
lord.
would like, after that question, kindly state your prayers. And then.
Okay. Very much obliged, my lord. Under Article 56 of the Constitution, it states that the state should provide affirmative action that promote inclusivity and does not discriminate. The Nubis and Somalis have long been discriminated. There are historical injustices that have been observed, and I will state that data protection must be upheld, and even as the NIIMS had been implemented earlier, there will be following regulatory frameworks that would have come with it, because even after the Data Protection Act was enacted, it did not, there was nothing that enshrined the protection of the data that has been collected, including the retina scans and the GPS locations. I'd like to conclude by stating our prayers.
Before you conclude, your submission is that there are existing frameworks which NIIMS are not following.
Yes.
Okay, state your prayers.
In light of the foregoing, we respectfully aver that this honorable court declares NIIMS unconstitutional under Article 31, finds that NIIMS discriminates against marginalized groups under Article 27, and issues an order nullifying NIIMS. Thank you.
Thank you, Council. The respondent, whenever you are ready.
Greetings, honorable members of the bench. My name is Melanie Nyaga, and I'm the lead counsel for the respondents in the matter presented before you. And with me are my co-counsel, Derek Omalwa, who will be presenting on issue B and will use 7 minutes. Charlene Disio, who will be presenting on issue C and will use 5 minutes, as well as Bran Onyango, who will be using 5 minutes and presenting on issue D. I will be handling issue A, and may it please the court, can I proceed?
How long will you be taking?
I'll be using 5 minutes.
Proceed.
Thank you. The first issue I'd like to handle is whether this court has jurisdiction to hear this appeal and determine it. And in acting for the respondents, we do concede that the Supreme Court possesses jurisdiction to hear this appeal pursuant to Articles 163(4) A of the Constitution, which states that the Supreme Court possesses appellate jurisdiction to hear and decide on appeals on matters constitutional interpretation or application. Furthermore, if you could move with me to paragraph 29 of the fact sheet, we see that the Chief Justice emphasizes on the Supreme Court's duty to uphold the Constitution while ensuring that governance systems evolve to meet contemporary needs. However, we would like to persuasively rely on the decisions from the High Court and the Court of Appeal in the matter, as seen in paragraph 6 of the fact sheet, where we see that the High Court upheld the National Integrated Identity Management System, NIIMS, subject to the enactment of comprehensive regulatory frameworks which complied with the constitutional safeguards. Furthermore, in paragraph 9, we see that the Court of Appeal upheld the High Court's ruling where it stated that the legislative process for the enactment of NIIMS did not amount to a material breach of the constitutional requirements. And as such, we deem that the enactment of NIIMS is necessary as provided for under paragraph 1 of the fact sheet. where we see that this system seeks to consolidate all personal information of Kenyan citizens and resident foreigners into a single digital platform for efficient service delivery as well as national security purposes. And as such, we would like this court to uphold the rulings of the Court of Appeal as well as the High Court persuasively. In approaching the second limb of our argument, we are of the standing that the respondents also have the requisite locus standi to defend their case in this matter. The appellants aver that their rights to privacy as well as public participation were not upheld in the enactment of NIIMS. However, pursuant to Article 24 of the Constitution of Kenya 2010, we see that this right to privacy is not absolute, it is limited, and it is subject to limitation as long as the limitation is justifiable in an open and democratic society based on human dignity, equality, as well as freedom. Now, in enactment of NIIMS under paragraph 5 of the fact sheet, if you could move with me there, we see that in the enactment of NIIMS, there was adequate public participation proven by parliamentary hearings, public advertisements, as well as...
Counsel, could you kindly restate your statement before?
NIIMS.
There's something really...
Very much obliged. Now, I stated that the right to privacy, which the appellants are averring was infringed upon, is not an absolute right. This is seen under Article 24 of the Constitution of Kenya 2010, where under subsection 1, we see that these rights are subject to limitation only if the limitation in question is reasonable and justifiable in an open and democratic society based on human dignity, equality, as well as freedom.
Can you the limitation that just stated? Is there any equality here on the Nubian side?
Very much obliged, my lady. We see that in the enactment of NIIMS under paragraph 5 as well as 22, before the enactment of NIIMS, there was extensive public participation, and in assessing the Supreme Court's threshold under the Supreme Court Act number 7 of 2011, we see what amounts to sufficient public participation as to validate the claim that there was adequate public participation.
Counsel, I would like you to respond to the applicant's assertion that marginalized communities were efficiently excluded due to language, geographic, and other barriers, despite the measures taken.
Very much obliged, my lord. My co-counsel will answer the question. However, I would like to provide a response to the question. We see that in enactment of NIIMS, public participation is paramount. However, it is impossible to reach in every individual citizen of Kenya in the matter for public participation. However, there is a threshold that has been set to see that majority of the people know of this and approve of it before it is passed. And in assessing the matter of the Nubians as well as the Somalis, we see that indeed there was public participation through public advertisements as well as stakeholder consultations. However, we know that the national language of Kenya is English as well as Kiswahili. Thus, public participation was conducted to a sufficient level.
There was sufficient public participation?
Yes.
Proceed.
Similarly, we see that... yes.
I'd like to draw attention to paragraph...
Yes.
Not paragraph 8, paragraph 7 of the case facts.
Yes.
We see that there is dissatisfied with the High Court's partial approval of NIIMS. The appellants moved to the Court of Appeal, seeking to overturn the decision. They maintain that lack of clear legal safeguards posed a risk to data security. Can you kindly show us in the case?
Very much obliged, my lady. If you could move with me to paragraph 23 of the case facts. We see that the respondents also contend that data collected under NIIMS will be stored in highly secure central database with multiple layers of encryption and access controls. They argue that safeguards like user authentication and data anonymization will prevent misuse. Moreover, to bolster their position, they cite the system's potential to streamline electoral processes, national census exercises, and disaster management efforts by providing real-time and accurate population data. We thus aver that this is sufficient to ensure that the right to privacy as well is protected under the Constitution.
Council, your time is far much spent, and we have extended you by 1 minute.
Thank you.
I will add you 30 seconds to conclude on your submissions.
Very much obliged. And in issuing our prayers, we would like to ask this honorable court to discretionarily rely on the High Courts as well as the Court of Appeals ruling in the matter and dismiss this appeal. Thank you. I'd like to cede the floor to the next co-counsel.
Honorable members of the bench, for the record, I'm Wamalwa Derek. I'm going to handle issue 2 on whether the enactment of Section 9A of the Registration of Persons Act violates the core principle of public participation and it breached the parliamentary procedure. I'm going to answer the question of public participation in 2 limbs. In the first limb will be public participation was conducted, and the second limb will be whether public participation was reasonable. May it please the court. We as the appellants would like to submit that public participation isn't a plebiscite. It doesn't require every individual to be consulted at a personal level. It is an engagement tool whereby a reasonable opportunity is provided to the members of the community. We like to put our reliance on the Supreme Court case.
Counsel, before you proceed, I asked your co-counsel this question. I would like you to respond to the applicant's assertion that marginalized communities were effectively excluded due to their language, geographical barriers, despite the measures taken by the government.
Thank you, Honorable Justice. Can you reiterate the question, please?
The applicant submitted before this court that marginalized communities were excluded by the government due to their language barriers as well as their geographic. Kindly respond to that.
Okay, thank you. Okay, I'd like to respond to this question using the Memorandum of Public Participation Bill of 2024 in defining the minimum public participation threshold. It was assessed that it is going to be based on the number of participants involved and the representative of stakeholders groups. So here according to the fact sheet, they have not indicated how many participants were consulted. Another thing, we have in paragraph in paragraph 5 of the
council, the data collection by NIIMS was countrywide.
Yes.
Doesn't that include even people living in the marginalized communities?
Yes, it includes. But the issue of public participation is not every member of the community, not every stakeholder is going to be consulted at a personal level. That's the issue. So even in the enactment of the 2010 Constitution of Kenya, not every member of the community was consulted. But here we have our Constitution. If I may proceed, I like to submit that we are putting our reliance on the case of Doctors for Life International by Speaker of the National Assembly. It's a South African case of 2006, number ZACC number 11, whereby I like to quote the words of Justice Swekea in his conclusion. He said, Parliament... Counsel,
before you proceed, can we have the facts of the case?
Yes, I can give you the facts. So the case was about the South African Parliament had passed a health bill, and in passing the health bill, there was a petition in court that they didn't attain the the public was never consulted adequately. So the issue was you have passed a bill and the public was not consulted. So those are the facts of the case. Okay, Justice Wekaya said in his decision, Parliament is required to take reasonable steps to facilitate public participation, but it is not obliged to ensure that all views prevail. Not all views is going to prevail. We further rely on the case of Minister of Health and another versus Nuclex, South African case also of 2005, ZACC number 14, whereby in the holding, the government had introduced a price regulation for medicine, and some stakeholders claimed that they were not adequately consulted. So the court held that public participation takes various forms, and what matters is whether public had reasonable opportunity to be heard. So it takes various forms. I like to direct you to paragraph 5 of the fact sheet, whereby we as the respondents argue that the data collection process adhered to constitutional principle and the adequate public engagement was conducted through parliamentary committee hearing, public advertisement, and stakeholder consultation. So these are just forms of public participation. On answering the question of whether public participation was reasonable, I like to rely on the case.
Counsel, before you proceed, can you address the issue on the public, on the legal notices being published in English and Kiswahili and were inaccessible to significant sections of the populace due to linguistic diversity, literacy levels, and geographical isolation?
Okay, in answering that question, we put our reliance on Article 7 of the Constitution, whereby the main language in Kenya is English and Kiswahili, so we couldn't exclude or add other indigenous languages.
And what about the geographical isolation?
On the literacy level and geographical location, I'm going to answer in this case law. So in the case law of Kenya Small Scale Farmers Forum and another versus Republic of Kenya and two others, a 2013 case law in the High Court. So Justice Majanja, Justice Lenaola, and Justice Mumbi, as then they were in paragraph 69, stated that the fact that the state didn't involve the petitioner can't be said it invalidated the whole process, which was already in its final stages. Will that suffice?
Counsel, your time is far much spent. I will allow you 1 minute to conclude.
I'll ask for the court to, I'll borrow 3 discretionary minutes for the court. 3.
3 is too much. I'll give you only 1 minute to conclude.
Okay, I'd like to submit that the appellants have averred that omnibus bill aren't unconstitutional. So it's our submission that omnibus bill are legitimate tool used globally to stimuli legislative process. And I'd like to quote, I like to rely to the report by Institute of Economic Affairs in analyzing omnibus bill in Kenya, which said that the only difficulty is it meeting the stringent public participation requirements. Another thing, I like to quote Article 118 of the Constitution, sub-Article 1, whereby the Parliament shall facilitate public participation and involvement in legislative and other business of Parliament and its committees, and that we put our reliance on. And I'd like to direct you to paragraph 5, whereby parliamentary committees were established. Another thing, I like to submit this quote that it has been a trite law that whoever alleges must prove. So it is for the appellants to prove how ineffective, how inadequate public participation was, and they are there to prove. And I like to put reliance on Section 107, 1 Cap 80 of Evidence Act of Kenya, whereby whoever alleges must prove. So the burden of proof really lies on the appellants. And
so, counsel, you are submitting that the applicants did not prove their case beyond reasonable.
They had to prove how inadequate, how unreasonable public participation was.
Can you then give us evidence from the fact sheet showing that public consultation process was both adequate and genuine?
I think that's the duty of the appellants.
The respondent give us concrete evidence that public consultation was adequate as well as genuine.
We as the respondents, we like to put a reliance on paragraph 5 of the fact sheet, whereby public engagement was conducted through parliamentary committee hearings, public advertisement, and stakeholder consultation. And furthermore, in paragraph 23 of the fact paragraph 22 of the fact sheet, the respondent, we emphasize that the public was notified about the system through extensive media campaigns, stakeholder forums, and parliamentary proceedings. The appellants are here to prove how inadequate the notices was, how inadequate the community was consulted. They are here to prove and to show us how inadequate they were. And
Thank you, Council. Your time is up.
I like to state my press and then I cede the floor. So, we as the appellants urge that this court find that enactment of Section 9 Section 9A in the Registration of Person Act was lawfully enacted. Thank you.
Thank you, Council.
I'll cede the floor to my co-counsel.
Greetings, Honorable Justices. My name is Charlene Disio. I'm the third counsel representing the respondent. If it may please the court, I'd like to proceed.
How long are you going to take?
5 minutes.
Proceed.
I'm going to address on the issue whether the National Integrated Identity Management System violates the right to privacy under Article 31 of the Constitution of Kenya 2010. The National Integrated Identity Management System does not violate the citizens'
Council, there is a lot of noise from outside. We are struggling to hear. So,
The NIIMS system does not violate Article 31 of the right to privacy of the citizens in the Constitution of Kenya. However, it does limit pursuant to Article 24, where the right shall be limited by law only to the extent that the limitation is reasonable and justifiable in an open and democratic society. Your Honor, move with me to paragraph 1. The NIIMS was established for the purpose of efficient service delivery and national security purposes. This amounts to public interest that the system is going to, I'd like to retract that statement, my ladies. The NIIMS was established for the purpose of efficient service delivery and national security purpose. With the previous system that was being used to store data, we were susceptible to identity fraud, service duplication, and inefficiencies in public administration, as highlighted in paragraph 8. The NIIMS system, however, is a centralized database that would like to mitigate these risks. The inclusion of the data under paragraph 16, move with me, my lady and my lord. And under paragraph 16, the inclusion of the DNA and the GPS coordinates is intended to enhance accuracy of identity verification. The DNA is unique to every individual, hence it cannot be duplicated. This is going to help us. This is going to help the government in providing the accurate information about
Counsel,
each individual.
The technical and the infrastructural structure of the NIIMS is compared to the Aadhaar system. And as we see in the Aadhaar system case, the issue on the duplication of fingerprints and retina scans was very, very widespread. What do you mean when you say that duplication is not possible in this case, while technically and infrastructurally they are the same system?
Much obliged, my lady. Duplication of the DNA is very difficult because of the variation of the DNA sequence. This makes the DNA unique to each individual. In regard to the retina scan, it changes with age and cannot be duplicated. My lady, it cannot be duplicated. We have to understand why the other system had these privacy issues. The first reason is the demographic data of the number of people was leaked on our website. This goes on to show that the system where the data was being stored was not secure enough. Secondly, the Aadhaar Act does not have a provision on the matter of notice, because the Section 47(1) of the Aadhaar Act provides that one cannot go before the court on the issue of data misuse. However, in the Constitution of Kenya, in the laws of Kenya, under the Data Protection Act of 2019, Section 29, the data subject will be notified that the personal data has been collected. Furthermore, with regards to the retina scans, which change with age, we have the Access to Information Act 2016, which allows the correction of information. Therefore, with the change of the retina scans, you can go and update your information, because Section 13(1) of the Access to Information Act 2016 provides that an applicant at the request of an applicant, a public entity or a private body shall within reasonable time at its own expense correct, update or annotate any personal information held by it relating to the applicant which is out of date, inaccurate or incomplete. Therefore, with the change of the retina scans which goes with age, you can still be able to go and update it.
But counsel, before we proceed, the High Court declared the collection of DNA and GPS coordinates unconstitutional, citing their intrusive and unnecessary nature.
Much obliged, Your Honor. The reason why the government wanted to include the DNA and the GPS coordinates is because it intended to enhance the accuracy of identity verification. Move with me to paragraph 16, my lord and my lady. Under paragraph 16, the respondents also assert that the inclusion of DNA and GPS coordinates was intended to enhance the accuracy of identity verification. They argue that the High Court's judgment effectively addressed any constitutional concerns by declaring these specific provisions unconstitutional while upholding the broader framework of NIIMS. So therefore, the intended purpose of having the DNA and the GPS coordinates was to enhance accuracy of identity verification, my lord.
Counsel, on the issue on duplication, has the respondent come up with any way based on the results that occurred in the other system? Have they come up with any solutions to the issue before implementing, or rather using the same technical and infrastructural is the word it's refusing. Technical and infrastructural, the way other system is technical and infrastructurally same with the NIIMS system. Has the respondent come up with any way or any solutions to counter the effects that occurred with the other system in India? Are there anything that the respondents have done to avoid the duplication?
The reason why the other system or the data that was collected by the other system was leaked was because there was not enough security for the data. However, move with me to paragraph 23, my lady. The data collected the respondents also contend that data collected under NIIMS will be stored in a highly secure...
Counsel, my issue is not on the security part. My issue is on the duplication part. What are the measures the respondent have come up to avoid duplications of DNA fingerprints and all of that, and the retina scans?
Much obliged, my lady. You cannot duplicate the retina scans. You cannot duplicate the retina scans. What happens? The fingerprint is also unique to each individual. That's why it is always being used even in the national identity card, because you cannot duplicate, because everybody has a different...
But you see in the other system there was duplication of fingerprints.
The main issue with that system was the fact that the data was leaked to a website. The data of 500,000 minors was leaked to a website.
Counsel, your time is far much spent. But I will add you also 1 minute. And in that 1 minute, I want you to respond to this question. How do you justify the proportionality of this data collection under Article 24, ensuring that states' interests do not unduly infringe on the privacy rights of individuals?
Much obliged, my lord. Will you reiterate the question, please?
How do you justify the proportionality of this data collection under Article 24, ensuring that states' interests do not unduly infringe on privacy rights of individuals?
Pursuant to Article 24 of the Constitution, the right of an individual...
Counsel, before you respond to that question, I have an additional question, so I'll add you like 30 seconds to answer it. You've stated the main issue in the DAR system was on the security risks. But in paragraph 30 of petition number 58, 56, 58, 59, we see the issue of duplication being seen in the DAR system. Are you trying to mislead this court, counsel?
Much obliged, my lady. Paragraph 30.
Note of the case facts of petition number 56, 58, and 59.
Could you please reiterate what it says?
Pardon?
Could you please reiterate what you've just said?
You've stated that the main issue in the Aadhaar system was on security risks and the duplication issues were not present. But in petition 56, 58, and 59, in paragraph 30, we're seeing the issue of duplication being addressed in the court. So are you trying to issue was not present in the Aadhaar system?
No, much obliged, my lady. I'm not saying that the duplication was not there of the fingerprints. However, the retina scans were not duplicated because this is impossible. The main reason as to why I'm saying that there was an issue with the demographic data of the people that was leaked on our website, this goes on to show that the Aadhaar system was not secure enough, which is why the respondents under paragraph 23 have ensured that this data collected will be stored in a highly secure central database with multiple layers of encryption and access controls to mitigate the risk of duplication and leaking and data misuse. My lord, could you reiterate the question that you had asked me, please?
I'll give you only 30 seconds. The proportionality, justify the proportionality of collecting data under Article 24. On one hand, you have the state interest. On the other hand, you have the right to privacy of individuals.
A right of an individual can be limited when it is required for national interest or national security or public interest. Article 238(1) of the Constitution of Kenya defines national security as the protection against internal and external threats to Kenya's territorial integrity and sovereignty, its people, their rights, freedoms, property, peace, stability, prosperity, and other national interests. With the previous system that we are having in the country, there were cases of identity theft which infringe the national security. When it regards to public interest, it is within the public interest to have a streamlined government, a streamlined process of which the government may efficiently effect its services.
Thank you, Counsel.
With the foregoing reasons, I'd like to urge the court to dismiss the appeal. I cede the floor to the next counsel.
Thank you.
Honorable Justices, my name is Brian Onyango, and I'm going to present on the third issue, that is on whether the implementation of NIIMS disproportionately discriminates against marginalized communities, contrary to Article 27 of the Constitution.
Counsel, before you proceed,
Okay.
there is a lot of noise coming from that end. We are struggling to hear you. Can you raise your voice?
Oh, okay, much obliged. Okay. Honorable Justices of the Court, and my name is Brian Onyango, and I'm going to present on the third issue, that is on whether the implementation, on the fourth issue, that is whether the implementation of NIIMS disproportionately discriminates against marginalized communities, and whether this amounts to contravention of Article 27 of the Constitution. Before we begin, I would like you to allow, I would beg you to please allow me to restructure the time that was allocated. Initially, we had planned for 4 minutes for rebuttals, but I'd like you to reduce it to 1, so that you can allow me to have the extra 3 minutes. Is that okay with you?
So how long are you going to use?
5 plus 3, that is 8 minutes. Okay. The appellants in the submissions, in the oral submission, if I'm not wrong, made 2 assertions. The first assertion, and I quote, the Nubians and Somalis have been long discriminated. In these 2 assertions, in these 2 statements, I want to point out two things. First of all, is the claim is unsubstantiated, and the other point is that it is inaccurate. With the first statement, the Nubians and Somalis have been long discriminated. You see, that statement is in itself not specific. In that, how are they being discriminated? Is it on grounds of sex? Is it on grounds of ethnic or origin? Or is it on grounds of orientation? That is the first statement. The second statement that they made is that the Nubians and Somali communities are barred from obtaining identification documents. That statement barred, I think it has been misused, because if you look at the definition, the dictionary definition, that is not even the dictionary definition. The Black's Law Dictionary, dictionary definition of bad, bad means to be prevented from doing something or not allowed. You're not allowed totally to do something. And I want to say that this statement is inaccurate. Why is it inaccurate? I'd like to take you to paragraph 14 of the fact sheet. And
Also, before you even proceed,
yes,
do you have any backing to your submission?
yes, I have backing. With regards to the inaccuracy that that the marginalized members of marginalized communities, members of the marginalized communities have been barred from obtaining identification documents, I'd like to take you to paragraph 14, which states that members of communities that live in border regions, particularly the Nubian and Somali communities, face systemic barriers. Paragraph 14 of the fact sheet. Members of communities that live along borders, particularly the Nubian and the Somali communities, have faced systemic barriers in obtaining identification documents. If you look at this petition while at the High Court, you're going to infer from the general point. If you look at systemic barriers here, it means something. It is a general term. It is not a specific term. And the specific term is inferred from this petition while at the High Court.
Counsel, you are losing me. Kindly
okay, I repeat the statement. The statement says that members of border communities, such as the Somali and the Nubians, face systemic barriers in obtaining identification documents. If you look at that statement, you're going to realize that systemic barriers is a general term to mean something, something else. What is these systemic barriers?
What does it mean?
Okay, that is where I'm going to. So I stand guided. Okay, but that is where I'm going to. If you look at the systemic barriers, if you look at petition 56, 58, and 59 of 2019, that is the Nubian Rights Forum, and 2 others versus the AG, and 6 others, petition of 2019. In paragraph 925, you're going to see that this systemic barriers is the vetting process that the marginalized communities are being subjected to. I'm becoming more specific. That is the systemic barriers that the members of the marginalized communities are being subjected to. Moving on to the earlier statement that...
Counsel?
Yes?
I'm not understanding your submission. What's your submission?
I'm talking about whether the implementation of NIIMS disproportionately discriminates against marginalized communities. However, if you look at paragraph 14, we have 2 parts. We have the first.
Do you think it discriminated the marginalized communities?
It did not discriminate. What it did is differentiated. What it does, it differentiates. It differentiates between. Okay. Moving on. If you look at the systemic barrier that I'm referring to, here is the vetting process. And you're going to realize that members of border communities...
Counsel,
yes,
you referred to petition 56 and 58 and 56, 58, 59, paragraph 925.
Yes.
What did you say the paragraph talks about?
I said that the paragraph refers to the systemic barrier as the vetting process. The systemic barrier being referred to is the vetting process that marginalized communities are required to undergo.
Oh, okay.
Okay, I continue. If you look at the vetting process, what it does is that it requires members of communities living along borders to undergo a vetting process, whereas members of other communities do not have to go through this process.
Counsel,
therefore, you're going to...
Where can we find that?
That petition, or that claim.
Yeah,
that claim, you're going to find it in this petition while it was at the High Court.
Do you have a case law?
The case law, the case law is Nubian Rights Forum versus, and 2 others versus the AG and 6 others, case of 2019.
And what are the facts? I really need to marry that case to this one.
Okay, the facts of the case is that the appellants, as they are now, in that case they were the applicants, they submitted their case that members of marginalized communities, such as the Somali and the Nubians, are discriminated when it comes to obtaining documents, when it comes to obtaining identification documents. And further, this discrimination would be perpetuated or would be exacerbated by enrollment into the NIIMS process. Okay, allow me to move to the the second part, you can see. If you go back to paragraph 14 of the fact sheet, the last part, it states that members of marginalized communities argue that NIIMS system exacerbates historical injustices by institutionalizing these disparities. And if you look at the act that created NIIMS system, the work of NIIMS is to collect information of Kenyans into one centralized system. That is the function. If you look at section 9A1 of the impugned law, that is the Registration of Persons Act, you're going to realize that the work of NIIMS is to collect the information, is to act as a national population register for all Kenyan citizens and registered foreigners resident in Kenya. And thus, if you look at the act, it does not bar anyone from accessing or from enrolling to its services, in that any person who is in Kenya, either a resident, either a foreigner or a Kenyan citizen, is allowed to access the services. Okay. And in addition, NIIMS as established does not require any form of vetting. The only requirement for you to be enrolled into NIIMS is that you be a resident of Kenya or a foreigner.
Counsel,
yes.
I want you to respond to this question. And I asked your first agent the same question. The applicant submitted that the NIIMS system discriminated against the marginalized communities, the Nubian. I want you to respond to that assertion that the NIIMS effectively excluded the Nubian communities due to their language, geographic, and other barriers, which include the systematic barriers. Can you respond to that first?
Okay, I'd like to state that the NIIMS system does not in any way or form discriminate against members of marginalized
Before
communities.
you proceed, I have an additional question to that. In paragraph 19 of the case facts, we see these people, the legal notices in Kiswahili and were inaccessible to significant sections of the populace due to linguistic diversity, literacy levels, and geographical isolations. The respondents do know that these people are marginalized people. They know they face linguistic difficulties, they have varying literacy levels, and they suffer due to geographical isolations. Isn't that discriminatory?
Sounds good, Your Honor. But with regards to the first question, I'd like to say that in terms of accessing or in terms of enrolling into the NIIMS system, there's no form of discrimination that takes place there. In the sense that
you are aware the marginalized communities,
yes,
they barely understand English or Swahili, yet they are required the NIIMS is required to apply to them, which is, I believe it's in English. Yet these people don't understand English or Swahili. Isn't that discrimination?
I stand guided, Your Honor.
Proceed.
I was answering the second allegations by the petitioners, or by the appellants, and that is on the claim that the appellants argue that NIIMS system exacerbates historical injustices by institutionalizing these disparities. I would like to state that with the NIIMS system, it does not require, or it does not discriminate against any person. The only requirement for you to be enrolled under the NIIMS system is to have identification documents. And if you look at the act that establishes NIIMS system, the identification documents are, it does not provide for the identification documents, or it does not issue identification documents. Therefore, the law that should be challenged on discrimination or issuing of identification documents with regards to different communities is laws such as the Birth and the Death Registration of Citizens Act, which provides for the birth certificates, and also the Refugees Act, which provides for refugee documents.
Counsel, your time is far much spent.
Allow me to state my prayers. Allow me to state my prayers.
Before you state your prayers,
Okay.
I'll give you 2 minutes to give us a summary of the entire submissions on your last issue.
My last issue.
Yeah, a summary of your entire submissions. Kindly.
Okay, with regards to the claim, I'd like first of all to state the claim. With regards to the claim by the appellants that members of Somali communities face systemic barriers, I would like to state that this is a false allegation in that the systemic barrier faced by members of marginalized communities is a process that is subjected to them for security reasons, and we should acknowledge that the right to discrimination is not an absolute right. It is a right that can be limited, and the vetting process.
The right to discrimination.
The right to equality and freedom from discrimination. Allow me to restate that. Is not an absolute right. It is a right that can be limited, and in this particular case, it was limited for security reasons, and it was limited by law, by Section 8(1)(a) of the Registration of Persons Act. And with regards to the second issue, or the second part, where they argue that the NIIMS system exacerbates historical injustices by institutionalizing these disparities, I would like to dismiss that claim in that the NIIMS system allows anybody, whether you are a Kenyan citizen or a foreigner, to enroll into its process so as to access its services. And in conclusion, I would like to ask this court to issue a declaration that NIIMS does not amount to discrimination under Article 27(4) of the Constitution, and that it applies to all Kenyan citizens and registered foreigners without imposing any form of discrimination. And with that, I cede the floor to you for further directions.
Kindly state for us the prayers for the respondent, all the prayers.
In summary, our prayers is that you dismiss this application for in summary, we would like the court to determine this appeal.
Counsel, you may cede the floor. Rebuttals.
Honorable members of the bench, we'd like to submit to this court that on jurisdiction, the respondents argue that this court lacks jurisdiction, yet the issues on appeal under Article 31 of public participation and in Article 10 are clearly constitutional.
But counsel, I believe the first agent for the applicant, for the respondent, did agree that the court has jurisdiction.
Yes, my lord. Public participation must be meaningful and not a mere formality. On equal application of an unfair system, it is not true equality. The system should strive for inclusivity and not discrimination. The respondents assert that it does not discriminate, yet the Nubis and Somalis have not been reached by the NIIMS system. On data privacy and proportionality, it is not proportionate that it is inconsistent when it is inconsistent, hence should be declared unconstitutional. The respondents, we as the appellants assert that the respondents have not referred to the fact sheet. They have stated that the systemic barriers is a vetting process, but paragraph 14 of the fact sheet clearly states that systemic barriers include prerequisite requirements of birth certificate and national identity cards. That's our submission. Sit the bench for further direction.
Do you rest your case?
I rest my case.
The respondent.
May it please the court, honorable members of the bench, in answering the question that the marginalized the Somali and Nubian people were discriminated from engaging in public participation, we would like to submit that the government has a duty to balance both public participation and urgent state interest, and we put our reliance on the case of FCCC versus Prometheus Radio Project 592 of US 2021, whereby Justice Brett has seen then was stated that FCC has authority to regulate broadcast media as public necessity requires. And I'd like to direct you to paragraph 8 of the fact sheet, whereby we as the respondent cited that the urgent need for an integrated identification system to address issues such as identity fraud, service duplication, and efficiencies in public administration. Thank you.
Under paragraph 7, the appellants move to Court of Appeal seeking to overturn the decision. They maintain that the lack of clear legal safeguards posed a risk to data security, and the deficiencies in public participation render the entire process unconstitutional. However, we as the respondents avert that there is adequate legal safeguards that are going to mitigate the risk of data insecurity. There is the Data Protection Act, which is in line with a global framework such as the General Data Protection Regulation. There is the Part 3 of the Computer Misuse and Cybercrime Act, and there is Section 83 of the Kenya Information Communications Act.
Thank you.
I see the floor for further information, for further direction.
Good afternoon. Good afternoon.
Good afternoon.
So generally, I had a nice session. I do have comments, but today I'm going to start with the respondent side, not the applicant side. For the respondent side, I have seen a very, very big improvement, a very big one. Congratulations, you guys. I'll start with Melanie. Melanie, today I really liked your presentation, or your submissions rather. You had a good intro. Today you had a structure. You had your court demeanor had improved. You had composure. You're not shaken by questions. You answered the questions well, and you had a good conclusion. The only issue I had with most of everyone here, you're not noting down the questions, and you ended up forgetting. Next time, note down the questions. For Amalwa, good intro, good structure. Organize your work. You're a little bit messy. Unatoa papers huku. Organize the work. Last time there was an issue on you answering the bench using your submissions. You had the answer in your submissions. There's a way you're supposed to. You did not work on that. Next time, work on it. You had good answering of questions. You used case laws very well. You have good composure. In fact, everyone in that team has good composure. None of you are shaken by questions that much. Your court demeanor has improved. And when your time is up, your time is up. When your time is up, your time is up. This goes to both sides. Just see the floor. Yeah, for the next agent, Shali. Shali, I knew you had a voice, and today you've shown us, and I'm very happy for that. You had a good introduction, good answering of questions, you had good composure. Same issue I had with everyone, noting down questions. Your court demeanor was okay. I wasn't satisfied with the answer, though. I wasn't satisfied. There's a part you lied to me, but I caught you. But thank you for having composure and lying straight to my face. I liked that. Your audibility has improved. Time management to all of you. Yeah. Your conclusion was rushed. You rushed your conclusion. On Onyango, your intro was good. You came with a lot of power. I really liked that. You came with a lot of power. You had expression, you're engaging us. But then you're thrown off. Again, you're thrown off. You are arguing with the facts of the case. Then we caught on to you. But you have good composure. And I usually like that about you. Answering of questions was okay, but you stood guided. Your submissions were hard to understand. I don't know. And next time, don't be shaken. Lie to us. Not lie to us. Okay, don't lie to us. Don't lie to us. But don't be shaken. The same energy you came in at the beginning, proceed with it. Even though you know you have no submissions, your submissions are off, proceed with it. I really liked the way you started. I wish you would have ended it like that. You did not have prayers. Prayers, 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 prayers. Next time have prayers. But generally, I'm really proud of that side. You guys have really, really improved. On the applicant side, I'll start with blessing. Your structure was good. You used good case laws today well. Your composure was okay. Today it was okay. You are not shaken the way you were last time. It has really, really improved. In fact, I've written improved composure. Your answering of questions were good. And I've also written very good. Like, I liked the way you answered the questions. Your court demeanor was okay. You weren't shaken by questions. I don't have any issue apart from not noting down the questions. That's the only issue I have with you. And for Nyarangi, why did I write Nyaranga? For Nyarangi, your structure was okay. You weren't shaken by questions. Guys, just note down the questions next time. I'll be a very happy person. You used the questions to advantage, but you were beating around the bush. Yes, I wasn't satisfied with some of your answers. Your court demeanor today has really improved, so congratulations on that. And both of you have very, very good confidence. In fact, all of you today had very, very good confidence. On the rebuttals, they were precise, straight to the point. I don't understand why the respondents had 2 people stating the rebuttals, but it's okay. That's all I have for today. Good luck to the ones who proceed.
Good afternoon. It was a great session. I enjoyed it. First, I'll give general comments. All of you had a good introduction. It was not hard to understand what you're going to present. Your court demeanor was also good. I was watching everyone to see if I will see anyone using their phone when the other guy was presenting, or the other side. For your rebuttals, they were on point, as well as the rebuttals. But for rebuttals, it's only one counsel who can rebut. Same for the rebuttals. You can't stand both of you. It's only one. That speaks to your teamwork, to see if you understand her issues, if you understand her issues. Also, one thing you have to practice now is time management. Nobody kept their time. Everyone. And especially the respondent. Now that you're presenting 4 individuals, your time you allocated 5 minutes each, or 7 minutes. You have to make sure your submissions you go on point. You don't hit around the bush. Go straight to the point. Another thing, when you're presenting, your desk has to be clean and neat. You people had a lot of papers. You are flipping papers side to side, side to side. And you know it can confuse you. It's like says you are not even ready to present or something like that. So next time, I think I told you last time, write a script on one paper or a foolscap or a book and come with it there. Present the entire script from one paper. That will first of all show us that you understand what you are going to submit, you understand the facts, you understand the issue, your submissions, you understand them well. Use the script to only refer to case laws. Like something that you don't understand well, you can refer to it for 1 second or even just look down. If it's a case law, the year, you're not sure about the year, you just look down, you get the year, and then you submit. Of course, you know you have to have the submissions in your head, everything, even the facts. Last time I told you, for whatever case you're going to cite before this court, you have to make sure you know the facts. And I asked you that question again to test if you people were listening last time. Another thing, what else? Understand your facts. Understand the facts, the fact sheet. You should understand all the issues, all the facts. Like only something basic. Facts unafaa kuwa nazo. Umekuwa nazo all that time. Make sure you have the facts on your fingertips. Now next time you can easily refer the bench. Another thing that you have to look is how to address the court. I have a document. I guess I will share it with you guys. I don't think you're supposed to say, I will show this, I will show the quote, I will rely on. Instead, you can say the applicant relies on article so and so. The respondent relies on the case of Okia Mtata versus so and so. Instead of saying I, use whatever you are representing. Is it the applicant or the respondent? Say the applicant relies on, the respondent relies on. And when you ask a question, don't give your opinion. This is not a court of opinion. You have to have the facts. If whatever you are being asked, you don't have the legal backing to it, rely on the facts sheet. The respondent in paragraph so and so said that we acknowledge this court's concern. However, on paragraph so and so, I will send you that document. Muyangalie. For you, the reason I asked you to set your prayers was to see if you understand whatever the other guys were presenting. That speaks to your teamwork. Make sure you have the prayers. All of you, you have the prayers on their fingertips. And also, for the prayers, they can either be a declaratory, an order, or you're seeking compensation. For example, for your case, let me check the facts. But for your case, you can say like, the respondent humbly asked this court to adjudge and declare that it has no jurisdiction, to order that this article did not follow public participation. You can either use declaratory or order prayers, like we declare or ask to order to something like that. So time management, I've told you about time management. One thing I liked about you guys, good reliance to case laws. In fact, you went ahead to even state the judges who are at the bench at that case, right? I do speak about Judge Lenola, Judge Mugambi, and so and so. That was a good one. Now, another thing, I guess that's all for me. But one thing also, like I told you last time, the applicant always preempt whatever the respondent is going to present. But do not say it like straight, because you can preempt something and they do not respond to it. But for the respondent, only make sure you are listening to whatever the applicants are submitting. Respond to their submissions. I heard you guys, whether you responded to whatever they were saying. Like the applicants asserted this and this. However, the respondent was the view that, you see, I guess that's all for me. I just gave general comments. But for you, I have to. I don't understand why you argued the facts to your issue. Like umetuambia, I don't know, systematic, whatever. It is not discriminatory. It was differential. Me hata sikuwa naelewa anything. Juliamua ku argue the facts, paragraph 14 and I think paragraph 23. Ungekuja hata na some I don't know, policies, some measures that you unaweza propose the government should have taken ama whatever. Never. Thank you guys. Yeah, he responded, but he was arguing the facts. Like